So, good morning. So, I am Danielle Morales. I'm a licensed educational psychologist and the clinical co director at the Bylund Clinic. And today I'm here to talk about limited conservatorships with attorney Damien Troutman. So, Damien is a senior associate with Leigh Law Group. He handles cases in employment law, special education and educational law, expulsions, suspensions, and many other areas of disability law, including regional center advocacy and work with adults. So, just to start us off, Damien, can you start by sharing a bit about your background and how you came to work with families on limited conservatorships and other related issues?
Good morning. I'm glad to be here. I started off, I've been an attorney for approximately 13 years now. I think that if you go back far enough, I think a lot of people who get into this area of law have some direct relationship with disability. Either they themselves have some form of a disability or a family member. I'm certainly no exception to that. I have an adult sister who had an IEP growing up, and while she is not conserved, I mean, she does receive disability-related benefits. I've been with the Leigh Law Group for about 8.5 years now, and prior to that, I represented plaintiffs in employment cases, and then I've been here with the Leigh Law Group since April of 2017, and so a lot of the work that I do is in special education and related litigation, but I also, me and my colleague Jay Janbeck, also have a practice that we represent families in limited conservatorships.
Okay. And so, just defining the basics for parents who are new to this, what exactly is a limited conservatorship and how does it differ from other conservatorships?
Okay, in the state of California, whenever a person turns 18, they are presumed to be an adult with all of the abilities and capacities of an adult. Whether or not that's true is obviously a different story. A lot of my clients have various types of disabilities, various severities of disabilities. And so, for example, sometimes I'll have a client who maybe is on the lower IQ, is on the lower end of the IQ. In the eyes of the state of California, when they turn 18, they have all of the rights and responsibilities, whether they're ready or not. And so, and that's how it remains unless and until the family or another appropriate conservator comes forward and asks for either a general or a limited conservatorship. And this is a topic that can go on and on about, but in a nutshell, what a general conservatorship is that essentially when you're asking the court to basically provide one person or persons, or it can even be potentially another fiduciary entity, but whoever the conservator is, the petitioner is asking the court to basically give total control over that person's ability to make decisions, because that person fundamentally lacks the ability to do so. A limited conservatorship is a little bit different. It's a little bit more. It still provides a lot of essential controls and inputs, but it's not a general. And so, therefore, what I have observed in my time is that oftentimes the law will favor limited conservatorships because it's obviously a big deal to potentially take someone's decision-making ability away from them. So what a limited conservatorship is that under the California Probate Code, there are certain enumerated powers that a petitioner can ask for, usually related to health, like healthcare decision-making, educational decision-making, accessing records, the ability to contract. That's just some examples, but that's something that in my practice and in Jay's practice is that families will come to us, and sometimes they're already existing clients. Sometimes we've been representing them for years on special education matters. Their child is about to turn 18, and then they say, okay, well, now what? What's the next step? What's going to happen when my child turns 18? How do we plan for the future? And so if the child we feel would qualify for a conservatorship, then we can represent them in terms of approaching the court and asking, for, any of those 7 powers. And there's also other powers too, but just to keep it simple for your audience, is that fundamentally, a lot of limited conservatorships are focused on those 7 powers, and what powers can be assigned to the parents or whoever the proposed conservator is going forward in terms of the child soon to be adult.
Okay. And perhaps continuing on that line of thinking, can you explain the difference between a conservatorship of the person and a conservatorship of the estate, and in what situations a family might consider either of those situations?
Okay, that's great. Excellent question. So first, I am a lawyer, so I always have to start off by saying that these are general guidelines. I don't want any of your audience members to take this as legal advice, because obviously everybody's situation is specific, different and specific. And so it's important that they walk through this with, with a qualified attorney. But I would say, in a nutshell, just for informational purposes, when you're talking about a conservatorship of the person, that is when you are looking at, again, the powers of the ability to contract, you're looking at medical records, you're looking at educational rights, et cetera, et cetera. Things that are, rights and decisions that are unique to the person. When you are talking about a conservatorship of the estate, you're talking usually, in my experience, that's for somebody who has perhaps a sizable amount of assets, that is owed to the potential conservatee. Typically speaking, if the proposed conservatee doesn't have many assets, it may or may not be appropriate to get a conservatorship over the estate. Sometimes for the conservators, there can, you have to, on an ongoing basis, you have to provide reports to the court. And so if the person doesn't have many assets, it may create more work than it's worth, essentially. 2 things to note on that, though, is that having a conservatorship over the person or the estate is not mutually exclusive. You can have both. And also with conservatorships, they can change over time. Obviously, you have to go to the court again to seek permission, but the idea is that you can, it's completely feasible that a person may start off with a conservatorship of the person, and then circumstances change, they can reapproach the court and say, okay, now we need to have also control, estate powers as well.
Okay. I think that's a good point, that the situation is fluid. So once a conservatorship is in place, that would evolve over time, potentially.
Absolutely.
Okay. And why does this matter? So why might parents of a child with a disability consider pursuing a limited conservatorship as their child turns 18? So what are some factors or key things you're on the lookout for when recommending this potential option to families?
There's a lot of factors, but if I were to kind of boil it down into the 2 things that I hear most often from my own clients, I think it comes down to 2 things. One of them is just ability. I think that, this sounds funny to say, but I think given the Britney Spears case that was in the media, a lot of people, I think, in the last few years have had a greater awareness of conservatorships. And I don't know if there might be some negative connotations with that or perceptions of conservatorships because it's seen as a form of control or something like that. In my experience, it's, obviously conservatorships can be contested, of course, but the vast majority of the conservatorships that I and my colleagues handle are ones that are completely uncontested, by the proposed conservatee, by the probate investigator, by everyone. And because it's, I have clients who, as I mentioned earlier, maybe there's someone who has a low cognitive ability. They can't take care of themselves. And that's why we're here. That's why we're supporting. And oftentimes my clients have they have a wonderful relationship with their child. and they want to continue after the child turns 18, being able to support them and care for them as they have throughout their lives. And they want to ensure that they basically are able to care for the parents are able to care for them as long as they are, healthy and able. So to that point, the two things are, one is ability. Just can the person manage their own affairs? Can they make their own decisions? Many of my clients can, some of my clients cannot, just because of their disabilities. And so that's why. So that's one thing. It's like when this person turns 18, we need somebody to make decisions on this person's behalf in order to make sure that he or she is healthy and safe and all of that. The second one, and I think it's kind of related, although it's not always related to intellect, because sometimes I have clients who maybe are kind of average range intellect, but they still have a qualifying disability that makes them very susceptible to undue influence or some form of pressure. I can think of a number of clients in my mind where very sweet, kind children, but they're the kinds of children where if they did not have adult supervision, they didn't have their parents around or their teachers, it would be very easy for them to be hurt, defrauded, swindled somehow. And of course, no parent would ever want to put their child in that situation. And well, to be fair, a conservatorship it's not a magic shield, of course. It doesn't doesn't automatically, prevent any bad actors out there from trying to do something. It does create a durable form of legal recourse. So let me give you a very concrete example for your listeners. One of the things that a conservatorship court, one of the things that a conservatorship judge is going to ask, as part of the process is, were there less restrictive options available? So for example, could we have had the person sign a power of attorney? And a power of attorney in its most basic form is basically a contract that says, I assign X, Y, and Z rights or, responsibilities to a third person. So some might say, well, why can't the proposed conservatee just sign a contract over to his or her parents to access medical records or, contract or things like that? Sure, they could. But what happens if there is a bad actor out there? What if they basically convince them to, trick them or tell them to tear up the agreement or to revoke it or rescind it? That can happen. And the person then, once they revoke it, the power of attorney it can, in that situation, be null and void. Conservatorships is fundamentally a court order. In order to change the conservator's rights, you have to go back to the court and get an order from a judge saying, X, Y, and Z. So it just creates safeguards. It creates protections. It gives the parents a sense of recourse in order to, if something does go wrong, it's a lot less easy to undo a conservatorship or to walk it back. And it's also, if something does happen, if there was a contract that was entered into that shouldn't have been, have a document saying this person never had capacity to begin with. They needed to have gone through, mom or dad or whoever the conservator was, rather than the bad actor or whoever that was.
Okay, that makes a lot of sense. Thanks for providing those different types of examples, both on the spectrum of making decisions around, personal health or just managing the complexities of day-to-day life. And then also the social factor, right? And protecting, individuals with different types of disabilities from those that may be trying to manipulate, exploit, take advantage of. So those are good considerations to think through. In terms of the process, so what does the process typically look like? So what steps are involved and what should families expect in terms of time and complexity?
I'm going to give you that horrible lawyer answer of it depends, because it kind of does. Sometimes I've seen conservatorships, especially when they're uncontested and they're, relatively quick and efficient. And I've seen other ones that have taken a very long time because either especially during COVID, when courts were backed up and the world was in chaos, there was a lot of moving parts. So it can take a long time. I would say, in my experience, maybe on the short end, the process might take maybe, I don't know, 3, 4 months. On the long end, I've seen ones that have taken over a year. So I mean, it just kind of depends. Um, what I would say in terms of the process, so you don't necessarily need, I mean, just in full candor and transparency, you don't necessarily need an attorney to file a conservatorship. Courts often have a self-help guide on their website and at the court to help unrepresented families. However, as with anything, it's always good to have an attorney if you can afford it, or if that's available to you. It is obviously it's a good option just because it helps you cut down on the mistakes, it helps you cut down on the delay, it helps you kind of understand your rights. Um, the typical process is first you have to file a petition with the court, identifying why the person needs a conservatorship, and then what power or powers you're asking for over the person. There's a lot of steps and there's a lot of forms. I'm not going to go into all of that because that would take a very long time, but just in broad sweep, what the court does then is they will initiate a process where they will send a probate investigator to basically investigate the matter. And what they're really looking at is, does the proposed conservatee qualify? Do they have a disabling condition that would qualify them for conservatorship? And then they're also kind of checking out the proposed conservator, to make sure that the person or persons or entities are appropriate, that there's no concerns, again, about undue influence, fraud, any kind of malfeasance or anything like that. Because the whole process is supposed to protect the proposed conservatee. Now, this is not, they they will ask for information about the proposed conservators' backgrounds, if they have a criminal history, et cetera, but it's not a criminal investigation. They're not there to necessarily make the proposed conservator look bad, or they're not trying to, scrutinize them in an unreasonable way. In my experience, most of the time, it's a pretty straightforward process. They will come to the house, they will do some interviews, kind of a site visit. At the same time, they will also, the court will also very often assign, unless the proposed conservatee already has like a private attorney, a lot of times the court will appoint an attorney at no cost to the family, no cost to the conservatee. And that lawyer actually represents the proposed conservatee. He or she is there, again, not always in an adversarial role, particularly where the conservatorship is uncontested. They are there more to make sure that the I's are dotted and the T's are crossed. They want to make sure that, that the proposed conservatee understands his or her rights to the extent that he or she can. They're there to make sure that, corners aren't cut basically in the process in terms of what notices were given and stuff, et cetera, et cetera. Again, every case is different, but in my experience, most court-appointed attorneys are have been very reasonable and very focused on just making sure that the right decision is being made in terms of whether or not the person qualifies for a conservatorship. That's all on kind of the courts side of things. On the family side of things, where Jay and I often advise families, is the family also, or whoever the proposed conservator is, also has to basically affirmatively provide evidence to the court that supports the person's need for a conservatorship. Oftentimes that's done on forms. It's a probate code is or conservatorships are very form driven. So there's a lot of things like physician declarations and other notices of rights and things like that we have to prepare and provide to the court. And then after this process, which again can take, sometimes months, then at that point, after all the reports are in, and actually before I forget, I should also say that for limited conservatorships too, in the state of California, it's required that, that the proposed conservatee undergoes an assessment by one of the regional centers, depending on where the family is located. It's also another part of the limited conservatorship process. And so basically, after all these reports come in, after all the forms are filed, after all the physician declarations, then the court will make a decision about whether or not the person qualifies for a conservatorship in the first place, what type of conservatorship, and what powers are, awarded to the family. Again, most of the time in my experience, it's pretty straightforward. Obviously, it can get less straightforward if it's a contested or something like that. And if there is a dispute, so for example, there are appeal rights, of course, if the family is denied certain rights, or if there is a decision that is adverse, of course, there are appeal rights too. But again, for most of the cases that we handle, they're relatively straightforward in terms of getting everything set up.
Mm-hmm. And as part of that process, are all limited conservatorships reviewed at the same cadence? Like, are they looked at annually by the court to make sure they're still appropriate, or is that case by case?
There are some, there again, without getting too deep into all the nuances of the probate code, there are some statutory requirements in terms of notification and updates to the court, just to make sure that because the court does continue to have jurisdiction over the case. So again, if there's changes that are necessary, other requirements, there are requirements. For example, just give a concrete example for your listeners. There are, examples where if the after the conservatorship is completed, if the conservator moves in certain circumstances, they would have to notify the court. Again, it's to prevent, exploitation, basically to protect the person. So there are some requirements that you would have to update the court and even possibly get approval if need be.
Mm-hmm. Mm-hmm. Okay. And then what are some of the biggest misconceptions or myths you hear from parents about conservatorships or just the general public?
I would say, again, kind of what I was talking about before, is that the idea from like the Britney Spears case, where it's kind of seen as like somebody is trying to control the person. Mm-hmm. This is some kind of draconian measure of taking away someone's civil rights or personal rights or something. And again, situations vary. I'm not going to comment on the Britney Spears case in particular, but I'm just saying that, of course, there are situations where the conservatorship itself is contested, or the extent of the conservatorship is contested, and obviously the conservatee or the proposed conservatee has rights to defend him or herself, to dispute it in court, etc. But I would say that for the vast majority of conservatorships that Jay and I handle here at Leigh Law Group, they are 100% uncontested. Everybody wants it. The family wants it. Sometimes their school districts want it, because obviously when the child turns 18, if he or she doesn't have a conservatorship, they by default have to make educational decisions for him or herself, and they may not be able to. So sometimes the school districts are saying, "Hey, do you have a conservatorship yet? We really need you to sign this IEP." So yeah, I think that it's sometimes it's seen as like I said, like a draconian thing, and I would say that while anything can be abused, and of course that's why we have laws, that's why we have legal safeguards, etc. The concept itself, I actually think, is kind of, getting beyond all the law, getting beyond all the legalities. I think that a conservatorship is kind of a beautiful thing in a way, especially from a parent standpoint. It's like, the clients that I represent, and even from personal experience, my parents were special education parents, and they their whole lives, they work to support my sister, and still do. And a lot of my clients, they are dogged advocates for their parent or for their kids. So it just makes natural sense that when their kid turns 18, they want to be able to continue that. They want to be able to continue giving them the love and the protection and the support so they can live, full and meaningful lives, and they can not have to worry about what happens if my kid needs, if we have to make a healthcare decision, having recourse if there's concerns about if they're going to be unduly influenced, and being able to manage finances and being able to make educational decisions. Even if the person's not college bound, doesn't matter. There are post high school educational opportunities for people with disabilities at various levels and abilities. And so this just basically allows parents to continue doing that. And it's, like I said, it's a great, wonderful thing from my perspective.
Hmm. Hmm. Okay. Thanks for talking through that and the protective aspect of the process. We've talked through a couple of these things already, like the role of the court. One of the things we didn't touch upon yet is the financial component. So, at a high level, again, not getting too into the weeds, can you talk about why it's important for families to connect a limited conservatorship with broader financial planning? So, estate planning, special need trusts, or any other thing like that?
Um, there again, I would say that it's one piece as part of the overall picture. It's a potential loose end that you want to make sure that you are able to address. You mentioned things like special needs trusts. That is more Jay's world than mine. He handles that way more than I do, but at a very high level, a special needs trust is basically it's basically I guess fundamentally in plain English, it's just kind of a managed financial investment account that has a lot of tax benefits, and also can, if a person, whereas certain government benefits have certain income limitations, things like that, a special needs trust can be an exception to that. So people can still have potentially sizable assets, but still qualify for certain government benefits. And so where a conservatorship falls into that is it's often natural that parents may have assets in a special needs trust for a young person. And then when the person is turning 18, that they are now at the point when, as part of the global picture here, you want to make sure that the parents or whoever the conservator is has, appropriate control and access to all funds, all controls in terms of the person's financial affairs.
Hmm. Hmm.
One
Okay.
thing I do want to say that one thing I do want to circle back on though, in terms of discussing kind of big picture and planning, uh,
Hmm.
because I don't want to, I want to give a clear picture for your listeners. One thing that's important to note is that I've always been talking about it as, when someone's planning for their child and when they turn 18, that is often a natural point when parents do seek a conservatorship. But there's no specific, statute of limitations or cutoff or deadline for getting a conservatorship. Sometimes for one reason or another, people get conservatorships later, later in adulthood for their child. I'm just discussing it from that kind of threshold point of when the student turns 18, just because that is the most often entry point that Jay and I see when we work on these cases, because of our existing special education practice.
Hmm. Hmm. So there's no age limit in terms of when to start or when the process could start. So somebody in their 30s may end up needing a limited conservatorship, for example. Is there a point during a teen's adolescence or kind of like that approaching 18-year mark that parents should start thinking about this?
Yeah, absolutely. And again, this is not I wouldn't call this like a hard legal deadline or anything like that, but I'll call it a best practice. I would say make it simple. I mean, and you can sometimes you see this, like if you Google this online, sometimes it'll say, I would say about 3 to 6 months. I would say a best practice would be 6 months before your child's 18th birthday, put a pin in the calendar. And at that point, if you want to start the process yourself, you can. Or if you want to hire an attorney, then start reaching out to attorneys. Because if you start 6 months from before the child turns 18, that should be, in most cases, I mean, oftentimes, unless there's some extenuating circumstance, that should be more than enough time to get the ball rolling and to start the process. I would say, again, there's no hard deadline, but that's just, I think, makes the most sense in terms of doing it in as calm and as orderly of a fashion as possible. Because sometimes if someone comes in and says, "Oh, my kid's going to turn 18 in 2 weeks," okay, well, we can get started, but it's pretty much impossible to be able to get a conservatorship by their 18th birthday in that time frame. So I would just say, as with anything, prior planning, helps make the process a lot smoother and a lot less stressful for everybody involved.
That makes sense. More continuity, not a gap between, 17 and then a year where there's no conservatorship coverage, so that it kind of rolls smoothly with the parents maintaining supervision of the child or young adult's affairs.
Yes, absolutely.
Before we close out, is there anything else that we haven't touched upon that you would like to note for parents or make sure that our listeners know about with these limited conservatorships?
I would just say that I would tell people that, again, this is coming just as my humble personal professional opinion, that conservatorships can be an amazing thing to support the young person as he or she is transitioning from, that K through 12 era to the post 18 era in terms of their development needs. So I guess this is not even a legal thing. This is more just, don't be intimidated. Don't try not to be obese. Jump into it with curiosity. If you feel like you can handle it on your own, there are resources out there for families. Usually if you go to your local superior courts, um, uh, self-help center, they have resources. Um, like I said, you don't need to have an attorney there, but is it helpful? Of course. Just because having an attorney, again, it's kind of like doing your taxes. Sure, you can go read all the tax laws, but sometimes if you have the ability to hire a CPA, it's easier because that way hopefully there will be fewer missteps, if any, and it can kind of make the process go a lot smoother. So I would just say, I mean, I think sometimes clients, they have busy lives. Sometimes they have children with complex needs. Sometimes it can feel overwhelming, and they're like, "Oh, that's just another thing we have to go through." And I hear about, so and so told me this, and I read this on the internet, and I saw this on social media or something. And I would just say, as much as possible, respectfully, try to block that out. Try to focus on what your loved one needs. And like I said, if you can handle it on your own, great. If you need an attorney, they're always free to contact us, contact our office, or another qualified attorney. I guess, and one other thing I'll add to that too is that conservatorships are driven by state law. So if you live in California, you should go to a California attorney. Go to a Nevada attorney. I'm sure there are many wonderful conservatorship attorneys in Nevada, but unless they're licensed in California, they're not going to be able to help you, and vice versa. So if one of your listeners is in, I don't know, Florida or something, if they wanted to contact us, I'm not licensed in Florida, so therefore, they should seek local counsel wherever they are.
Okay, that makes sense. So adherence to state licensing and state laws.
Yeah.
And building upon that, for families listening who may want to explore this further, we already talked a little bit about the services that you offer. How can they reach you? Are you taking new clients? All of that stuff.
Absolutely. So our website is www.leiglawgroup.com. That's LEIGHLAWGROUP.com. I can also give you our phone number. Our main number is 415-399 9155.
Perfect. Okay, Damien. Well, thank you so much for your time today. This is really helpful, and I'm sure a lot of parents are going to appreciate this crash course in limited conservatorships. Like you said, there's a lot of information floating out there online. So just hearing straight from someone who does this work is really valuable to distill it into the big picture. So thank you.
Absolutely. Yeah, the rabbit hole goes very deep, but I just wanted for today, I just wanted to give a kind of an overview to help people understand that this is something that is, the person qualifies, it can be a great thing, and it's always good to get help if it's needed.
Perfect. Well, thank you so much.
Thank you so much.